arbitrationagreements.org. Hello and welcome to this in-depth discussion on the basics of an arbitration clause in a contract. The aim today is to simplify this crucial aspect of contract law for you. Now, if you're watching this video, you are likely interested in the world of arbitration. You might even be involved in drafting or reviewing contracts. Arbitration is a form of alternative dispute resolution, an avenue that parties can take to resolve disputes outside of court. Its attractiveness lies in its confidentiality, speed, and control over who gets to decide the dispute. Let's delve a little deeper into how it works in the context of a contract. But first, please give this video a thumbs up, press the subscribe button, and hit the notification bell so you can stay up to date about important alternative dispute resolution topics, which can help your customers stay happy and keep costs low when problems occur at your company. An arbitration clause is a part of a contract that stipulates that any disputes arising from the contract will be resolved by arbitration rather than through the court system. Parties to the contract can decide to include such a clause to bypass potentially costly and lengthy litigation. Interesting to note, according to a recent study, over 90% of businesses preferred arbitration to resolve their disputes, citing confidentiality and the ability to select arbitrators as the most important features. This clause can be drafted to the parties' specific needs, and it usually specifies things like the method of selecting the arbitrator or arbitrators, the rules under which the arbitration will be conducted, the place of arbitration, and the governing law. Yet, it's not all roses. Be aware of a concept known as unconscionability, which, in layman terms, means an arbitration clause that is overly one-sided or oppressive could be set aside by a court. So, always ensure a balance of rights and obligations between the parties in the clause. As of this year, well over 8,000 commercial disputes are submitted for arbitration annually. This shows the frequency with which arbitration is being employed as a means of resolving conflicts. Now, let's touch on enforceability. An arbitration award, which is the decision made by the arbitrator, is final and binding. According to the New York Convention, an international treaty, arbitration awards can be enforced in more than 165 countries globally. That's a far-reaching power for an out-of-court settlement, isn't it? Remember, the power of an arbitration clause lies in its proper construction. A poorly drafted clause could lead to unnecessary litigation to clarify its meaning. Be careful, be precise, and when in doubt, seek expert help. In fact, our association is standing by to draft an arbitration clause on your behalf. Please visit arbitrationagreements.org. Our association does not provide legal advice, but many people from multiple industries use our services to navigate claims in a controlled manner through a cost-effective framework. If you're interested in doing that as a business, give us a call. In fact, big companies use arbitration because it helps them control costs. You're paying for one service per case instead of having uncontrolled expenses that any normal lawsuit would cost. That's the real reason people use arbitration. Also, what do you think about the basics of arbitration clauses? Does it make sense for businesses to protect themselves with clauses? Drop a comment below and let us know your opinion. Please do not forget to give this video a thumbs up, subscribe to our channel, and hit the notification bell so you can receive the latest updates about dispute resolution that can help your business succeed.